I'm Charles Burnham, one of the attorneys here at Burnham and Gorkov, and in this video we're going to talk a little bit about our firm's white-collar criminal defense practice. White-collar crime is a term of art. It's not a legal term, but it's a term that lawyers use to refer to criminal offenses that don't involve any kind of force or violence or drug dealing or traditional criminal activity. In practical terms, when you say white-collar crime, 90% of the time you're talking either some kind of fraud charge, of which there are various kinds, or a bribery, corruption-related charge. And most of the time, you're going to see these cases either in federal court or investigated by the FBI or another federal law enforcement agency. And we're going to tell you a little bit about some of the basic facts about these cases and how they work, some of our philosophies about how best to represent clients involved in these sort of cases, and some of our experiences in representing white-collar criminal defense clients. Like any criminal case, the fundamental question in a white-collar situation is what defenses do our clients have to the charges that they're facing. One of the unique things about the white-collar context, however, is many of the traditional defenses in criminal defense don't often apply. You don't see a lot of alibi defenses. For example, if you're accused of making fraudulent loans, it's probably going to be clear from the evidence that you made the loans, and the question will come down to whether they were fraudulent or not. And another way of saying that is, can the government prove that you made the loans with fraudulent intent? The defenses, the most common defenses in white-collar cases are that the defendant lacked criminal intent or that the defendant was acting in good faith is another way of saying that. So when we represent clients in public corruption, bribery situations, our job is to look through all the available evidence, the tapes, emails, documents, and find whatever we can to support a defense that our client acted in good faith, that they didn't mean to break the law, didn't mean to defraud anybody, didn't mean to do what the government said they did.
So given that intent is oftentimes a central feature of a white-collar case, how does the government prove intent? A lot of times what they do is they rely on circumstantial evidence. They say that just the acts that the person took are sufficient to show bad faith. And oftentimes those arguments simply are not true when you look at the practices of the industry and the context in which those facts took place. Another way that the government commonly tries to prove intent is through looking at a person's communication. Those could be written communications, they could be documents that the person authored, or they could be communications that a person had with witnesses that the government interviews and calls at trial. Oftentimes the government makes claims about things that a person did or thought that simply are not true. So as we'll discuss later in this video, it's important to conduct a very thorough independent investigation for our clients because the true evidence often tells a different story.
One of the important aspects of defending any white-collar criminal defense is a white-collar criminal case is to retrace the steps of the government investigation that led to the charges that your client's facing. Look at the warrants they obtained or served. Look at the grand jury activity. Look at how they got their evidence. And if you find any problem with the case, or more importantly, any legal or ethical rule that the government violated in their investigation, that can be the key to a successful defense.
A really important thing in white-collar cases is to understand that different industries and professions can be very specific in the way that they work. And so it's important, and we do this in our practice, is to consult with experienced people, with experts, qualified experts who know how industries work, who can look at the evidence with us, who can look at the facts of the case with us, and prepare us to address these facts in court. Oftentimes, claims that the government makes about the way that professions work or the way that industries work are not true. And having your own independent expert can be a very powerful tool.
Another unique characteristic of our white-collar criminal defense practice as compared to traditional criminal defense is that the clients are much more likely to know that they're under investigation before a formal charge is filed in a court. They've gotten a grand jury subpoena, the FBI has visited them, they've learned in some other way that the government's looking at them for potential criminal charges, which is important because in the white-collar context, that means the clients are much more likely to be able to get legal representation before facing indictment, which has several advantages. First, it gives you an opportunity to try and convince the prosecutors that no crime has been committed, at least not by your client, and that they shouldn't bring any charges at all, which is much more difficult to do once the charge has been filed and the prosecutors and agents are much less likely to change their mind. Secondly, if it's a situation where you're looking at a plea bargain, it's much easier to get a much more favorable plea bargain before charges have been filed than afterwards. And finally, if you have a situation where charges are inevitable and you're looking at a trial, which happens all the time, you're going to be in a much better position to defend against those charges if you've had legal representation for months before the charges have come than otherwise. And so if you have any reason to believe the government may be looking at you for a criminal case, get representation immediately to discuss what you're looking at and what you could possibly do to improve your situation.